Albert, for many of us, when NACDL's name is mentioned, you're the person who comes to mind as the leader of this association, as one of the great criminal defense lawyers, as someone who has nurtured thousands of criminal defense lawyers around the nation. Talk to us about NACDL and what it has meant to you through the years.
First of all, what you say is highly flattering, thrills me,
And
delights me, but I must disagree with it, even though I would love for it to be absolutely true and an accurate picture of what my life as a lawyer has been. But my life as a lawyer is in many respects measured by what has happened with NACDL. The relationships formed as a result of NACDL and the enormous steps that the NACDL has taken to make lawyers. And I'm sure that you know when I talk about lawyers, I'm referring to criminal defense trial lawyers. The lawyers who go into the pit are probably unloved by everyone in the courtroom, including the client, all too frequently, and have the courage, the strength, and the mind to make our Constitution live as a vibrant being in that courtroom on behalf of someone who stands for, at this little moment in his or her life, for all of the principles of liberty, individual right, individual freedom that can be articulated and that have been preserved in our Constitution. It's a chore in many respects. It certainly is difficult in all respects. But in the years that I've been practicing and listening to some of the other interviews, the years suddenly became much longer than they were when I came into this room and sat down. In a couple of months, I celebrate my 53rd birthday as a lawyer. And of the 53 years, I would say all but 2 or 3 were in the pit. And primarily trial. Yes, I've done some appeals, but I don't like it. I didn't like it all that much then. I like people. I like dealing with people. I like thinking with people. And it was my good fortune to be befriended by an extraordinary lawyer. And he put my feet on the path of being a criminal trial lawyer, showed me where the courthouse was, and even went further, showed me where the men's room was in the courtroom, a very necessary bit of knowledge, as we all appreciate. Gave me literally the strength to proceed into a field with which I was totally unacquainted. And he, of course, is the person who took me by the ear and put me in the NACDL when it was going through its birthing. I was in my early 30s. Gilbert S. Rosenthal was in his 50s. He was a man who stood about 6'1", had a voice that was gravel, operated with strength every single minute of the day, was a tiger to challenge, And in a case that was of great moment amongst the criminal bar back in the 50s, the so-called Appalachian case, that is the meeting of many people of Latin persuasion at a abode in upper New York State. And it became the subject matter of an enormous amount of litigation. And something clicked when I heard Gilbert Rosenthal say to the press, complaining about a decision which was adverse at that time. He said, I want to know why every time I raise a constitutional issue, I am told I am being dilatory. And it was an epiphany for me. It was a person whom I respected more than anybody else in the bar, who had suddenly, in a sentence, told me what my mission should be, if I can presume so much as to have a mission. When Gil took me into the NACDL, it was just the beginning group, and there were giants.
Tell us some names.
Percy Foreman, for one. Percy was bigger than life, absolutely bigger than life. My favorite story about, I have two favorite stories about Percy Foreman. One was Irene was giving birth to our third child. No, it wasn't the first. No, that was 1949. Okay.
Yes.
If you're going to argue, Irene, you got to stand up and put the chair and you sit next to him.
Yeah, why not?
Huh?
I have 5 kids and I lose count from here to there, you know. So Irene was giving birth to one of the children. Okay, thank goodness. She wasn't giving us a litter. She was only giving us one. And she was in the hospital. And I thought it would be nice to take my mother. This was the annual meeting, was being held in New York, and they were very formal affairs. This huge crowd of maybe 30 people would show up, everybody in dinner jackets, women in gowns. And the Candy Mosler case had just been tried. And Percy Foreman and Harvey St. Jean, who unfortunately, Percy lived out his life and passed away. Harvey St. Jean, criminal defense lawyer here in Miami, was executed in the parking lot near his office, which is a whole separate story. But they had just gotten this fabulous acquittal, and they were front page news all over the country. And my mother was an aficionado of criminal trials at that point and thought the world of Percy. So I bring my mother to this affair, and I say, Mom, you're going to meet Percy Foreman. She said, oh, how wonderful, Percy Foreman. So we walk into this room, I don't remember which hotel it was, and Percy is standing there, and I take my mother under the arm and bring her up to Percy, and I said, Mom, I want to introduce you to Percy Foreman. Well, Percy, 6'1", 6'2", voice that would break the windows. Your mother? That is not your mother. I tell you, he says that, and I began to doubt. Your mother? I would accept your daughter. You know? Well, let me tell you, if my mother was in love with Percy Foreman before, it was nothing. He made years of happiness for her. The second Percy Foreman story was, I would guess that the National College was in its second, third year. And they used to have what passed for a banquet on the last night of the college. And they'd hand out a piece of paper, you finished the courses, go out and do good or something of that sort. And we'd have a dinner speaker. And generally we would try to get somebody from the Texas area because couldn't afford the car fare. So Percy was asked to be the dinner speaker that particular evening. It fell on me to introduce Percy. So I'm standing up there on the dais and talking to roughly, I would assume, 150 lawyers, more or less, with some friends, and trying to do justice to Percy Foreman's reputation. And I feel anything that I say is really not going to be accepted. It is all too big. So I finally introduce him and I step away from the microphone, and Percy comes up there. I'm telling you, this is an actual direct quote. It has been said that I am the finest defense lawyer, trial lawyer in this country. I don't necessarily agree with that, but that is only one man's opinion. It was classic Percy. You know, how do you deal with persons such as that who, to a young lawyer's eyes, are so much bigger than life? Charlie Tesmer didn't do himself justice. The sparkle, the vitality that was in him when he stood before a group is rarely duplicated. Rarely duplicated. Extraordinary presence. Sam Dash, a mind, well, you could say almost in the movie of today, a beautiful mind. I've spoken about Gill. The Harvey St. Jean was just a delight. In all truth, he didn't have the equipment that a Percy had, or Gill had, or Charlie had. But he was a lawyer with whom to reckon. Maury Walsh out of Chicago, a giant. Morris Schenker, beyond reality, beyond. You asked for a story about Morris Schenker. I will give you true Morris Schenker. He's trying a case out in Colorado. And it was a Teamster case. And the prosecutor is a vigorous young tiger. He's going after Morris's client without any holdback in any respect. And comes summation. Morris spoke with an accent. He had been born in Poland and had come over to the United States in the 30s. More than the trace of the Polish Jew was in his voice. He was about 6 feet tall and in reasonably good shape. So he's summing up. He walks over to the prosecution table and puts his right hand on the prosecutor's shoulder. And Morris was strong. It's a grip of iron there. And of course he's smiling and beaming at the jury. The prosecutor's wriggling, trying to get this guy away from him. Morris's summation included the following. Ladies and gentlemen, I got a little boy. He's going to be a lawyer. I expect him to go to law school and become a lawyer. And I pray that when he's a practicing lawyer, he should have a better case than this fellow's got. Vintage Morris. Vintage Morris. You know, you become awash with memories. I recall so clearly feeling myself just so blessed that I could say, I stood alongside of, I spoke with, or so-and-so asked me even how I felt. The early years were learning experiences every single moment. Even though times changed, and if you permit me, I'll get to some of the changing times, but to a young lawyer, listening to the stories that, and I'll use the word again, these giants were telling, was a boon beyond my ability to ascribe a value. You would, as I said, hear a sentence from Gill that was a channel marker to you. The personality of Amara Schenker to bring humanity into the courtroom, to be able to make the most complex of legal issues relate to everyday and mundane problems so that all may understand them. The presence of a Percy, how important it was to walk into that courtroom and own it, but not with arrogance, not with strutting, but by something that would be coming from within you. And that which would come within you only could come if you had prepared, studied, and had that clear insight unto yourself to realize what your flaws were. If you had any strengths, well, God bless you for having the strengths, but recognize what you're doing wrong. I had a very, very dear friend, and we used to joke about trying cases together, ocean to ocean and border to border. Robert Kasanoff. He probably, well, we talked about a beautiful mind a moment ago. I don't know what the superlative to a beautiful mind is, but we often joke that he had an IQ of about 5,000, at least. And Bob, who was very outspoken, said, "You know what your greatest strength is, Albert?" Beamed at him. I figured, oh, this is going to be so good. I'm going to appreciate this. You know, this brilliant person is going to heap a praise on me, and I could just take it forever. He said, "You know when you're stinking up a courtroom." And, you know, I was taken aback for a moment, and then I realized that what he was saying was that I recognized the strength of learning. So we had the informality of learning in the sessions that Charlie described back then. I'm basically a non-drinker, so I could absorb what was being said. Most of them were unconscious. You know? I tell you, they were. Remember Bruce Hartigan, who we had a meeting at Key Largo. He came down 2 days early in order to train for the meeting. As an example. But It was an association basically of friends, of persons who had relationships one with the other. One of the original people, Paul Smith, from Massachusetts, from Boston, superb trial lawyer, of course. And Paul said, you know what is good about being a criminal defense lawyer? What, Paul? I recall my saying to him, almost snarling, what? Because I probably had just taken a beating someplace and wasn't feeling all that happy. And he said, no matter where I go, from one ocean to the other, if I meet a criminal defense lawyer, I meet a friend. And how true that is. We all have exactly the same problems, exactly the same frustrations. Some of us may not feel it as intensely because we can buy a Rolex, the name of which ends with an X. But, you know, but there is an understanding. And certainly in my life, it came, well, at one point, underscored in bold, if not in flashing neon. Neil Sonnet, who certainly must be measured as one of the great presidents that this association had, and I were in a case in, of all places, Fresno, California. And we show up in court, and we are promptly served with subpoenas to testify. Trial witnesses, forget about grand jury, trial witnesses. We are to testify as to our fees in order for the government to establish the essential element in a continuing criminal enterprise of substantial profit being earned by the enterprise, and the substantial profit would be rather nice fees that each one of us, that Neil and I had charged. Well, you know, there's the initial reaction, let them all drop dead. I don't care about any damn subpoena. And then, of course, you wake up the next morning and you say, what am I supposed to do? What can I do? Well, Neil and I promptly contacted the NACDL, never thinking for a moment that the strike force, which had been formed to deal with issues like that, would have to deal with us. So the response was beyond dramatic. Jerry Goldstein flew in on the day of hearing from San Antonio to address the court. Ephraim Margolin came from San Francisco to address the court. The questions were put to us, who else do you want? You know, how many do you want to show up? It was, to me, the first real demonstration of NACDL power, where we had come. I would guess this is 1974. No, it had to be in the 80s. It had to be in the 80s. The reason that I say that it was a demonstration of NACDL power was because Stephen Trott, who was then deputy and is now a Ninth Circuit judge, when he was informed that Neil and I had been subpoenaed, his reaction to the U.S. attorney for that district was, what in the hell are you doing? Every bar association and every lawyer in the country is going to stand up for them and against us. And they withdrew the subpoenas. We had argued it, etc. but it was the NACDL power. There was an organizational strength that had not previously been exhibited. It went to the extent that in 1985, this was a really bad experience in certain respects, but it worked out very, very well, was that there was such a thing called the Massachusetts Resolution, which was being presented to the House of Delegates of the American Bar Association. Gil Rosenthal, who had been the delegate from the NACDL for many, many years before that, Gil had died, and I was appointed by the association to take his seat, so to speak. So we, of course, had much to say, at least as to ourselves, as to this issue. We wanted the American Bar Association to adopt this Massachusetts resolution, which basically said that it would be unethical to issue a subpoena to a lawyer in respect to matters affecting a current client, particularly one that was involved in litigation of a criminal nature at that time. Neil and I flew up from Miami on a Sunday. We got to Annapolis, where the meeting was. Late in the afternoon, we were both tired, and we went to our rooms. We knew that the 60-minute bit on the NACDL was going to be run that evening. So we said, well, we'll get together and hit the typical cocktail party circuit after 60 minutes. I don't know if you recall that 60 Minutes program, but it featured some comments by Joel Hirshhorn and by Oscar Goodman. And 60 Minutes had wanted to do a broader interview of various lawyers from the NACDL, but Neil had gotten some undercover word from somebody who knew somebody who was one of the producers that it was going to be a hatchet job. Typical 60 Minutes editing and slanted reporting that they do at times. So we decided there's no way we're going on camera. What they did with Joel and with Oscar was horrendous. And we have to argue on behalf of criminal defense lawyers the next morning. We meet at about 7:45. We go to a cocktail party or two, and we're literally slithering in, you know, and hoping everybody started to drink early and that nobody saw the program. We took heat, not so much that evening, but the next day, in substantial degree, because of what was portrayed as lawyers chasing the dollar, lawyers chasing their own self-image, lawyers not dedicated to the representation, the fair representation of their clients in a realistic, appropriate sense. The matter was argued in front of the House of Delegates, and I remember that Neil spoke, you know, they alternate, for and against, pro and con. Neil spoke before I did, and then I spoke, and kind of educated the House of Delegates. And it may sound a little bit vain, but in this sense it's true. Those civil lawyers don't stand a chance when they're confronted with criminal trial lawyers. We know how to respond on our feet. We're flexible, we're adjustable, and we're so issue conscious. Our focus is literally razor sharp. When I finished, the bellows of "call the question" were figuratively shaking the rafters. Now, Steve Trott, the deputy, had spoken, had received special privilege of the floor to speak. It spent about 20 minutes talking about the government's position in respect to rejecting this resolution. They called the question. It was, for all intents and purposes, unanimous in our favor. It marked, insofar as justice is concerned, to this day, and now we're talking, what, 17, 18 years later, to this day, the NACDL as being an organization that must be given consideration. That when it speaks with strength. Well, starting at that time, we were able, through Steve Trott, to begin the liaison. And because it began through Steve Trott, it of course incorporated the approval of and participation of the Attorney General, Edmund Meese, who may not have the greatest reputation amongst many lawyers as being conscious of those things that we hold so dear. And it didn't take me too long to learn that I was overjoyed that he was the Attorney General, because he gave us his ear. And he, as we, was not afraid to learn. And he would turn frequently to Steve in the, I don't recall how many meetings we had with him personally. Is that so? That's the way that works? Well, we got to do something about that. Amazingly helpful, responsive, and I believe that many of us have not been indicted because of those meetings that took place at that time.
Well, Albert, let me ask you a question about that. Now, I recall being with you, meeting Edwin Meese. I know how pleased we were that we were making inroads at the Department of Justice. And I remember to this day, as many of us do, a meeting we had, a board meeting, when certain members, John Wall in particular of Boston, a former federal prosecutor himself, basically took you on, saying that it was outrageous that we would meet with the Department of Justice, who were our, quote, enemies in his term, using his term. And it was a real turning point for NACDL as we dealt with this divide among our own membership. Would you talk to that, please?
Well, I have some recollection of that particular meeting. And that meeting, I also tell you, is remembered in the Department of Justice. Judy Friedman, who was with the Department of Justice, still is, was there. She reported back. And it was extremely important from our ability to meet with and discuss matters of importance with justice, because the position was, shall we say, forcefully taken by me, and it had the approval of those who were assembled, that we are not enemies, that we are working towards a common goal, and that is the application of the Constitution to the individual, to making sure that there is vitality in the protections afforded to us under the Constitution. And by 1980, whatever year it was that incident occurred, I know I had learned that my father's advice that you catch more flies with honey than you do with vinegar was truly a watchword by which you should practice. That categorizing persons as enemies as such is not only counterproductive, it makes them enemies. A long, long time ago, when it was more fashionable to attack a prosecutor because you had no defense, so you'd attack the prosecutor. Sometimes it was customary to accuse the prosecution of all kinds of misdeeds, from pedophilia to God only knows what. Now, you learn that civility goes a long way.
I tell you, Albert, that meeting, that was one of the first meetings that I went to. And I sat out in the audience, and I watched you and John have at it. And I thought you guys hated each other. And I can still remember what it meant to me to see you after that board meeting with John, one of your good friends.
No, you're a little bit wrong there.
Okay.
You're a little bit wrong. Maybe I have to confess to being somewhat of a hypocrite. That wouldn't surprise me at all. I can hold a grudge, really, with the best of them. I never forgave him for that. Never did. And I also felt that the position that he took fed into what has always been a problem in the NACDL, and that is the thinking of some members that has best been articulated by our president these days. If you don't agree with me, you're a traitor. That we cannot evaluate our relationships within a system of justice in such stark terms. I have often said that I care little about what the verdict is if justice is being done. If the lawyer, defense lawyer, has done everything that he or she should on behalf of the client, and in as good a manner as can be possibly achieved, if the prosecutor has honorably fulfilled his or her duty to conduct a prosecution for a violation of law, and if the judge has ruled fairly and even-handedly with full consideration for the rights of the defendant. The defendant is prime. The defendant is a first consideration. If all of these three things come together, oh sure, I want to win. I want to win more than anything else. I'm a competitor. I've always been a competitor. But if all of these things come together, it's much easier to live with a guilty verdict. Oh, sure, to this day, I wake up at 3 in the morning, if I've been fortunate enough to fall asleep by then, and relive the day that has gone by. And I don't know how Irene has been able to sleep through so many of the nights with the tossing and turning and self-flagellation as to why did I do this? Why did I do that? Why? That's part of the price you pay. I remember a long time ago, I walked into the federal courthouse in New York, and Judge Francis F.X. McGoey, a really very good judge, spoke in the softest tones you could imagine and could just literally cleave you down the middle in those soft tones. And I was standing there in the elevator lobby, and he said, "Mr. Krieger." I said, "Good afternoon, Your Honor." He says, "How's it going?" I said, "Judge, I'm tired." And he looked at me and he smiled. He says, "Never complain to me about that. That's what you signed on to be when you became a criminal defense lawyer." And how true that is. You have to give so much of yourself in this practice. And if you don't have at least the reward of believing yourself to having come close to achieving the goal of having defended the Constitution, of having helped others to defend the Constitution, there's little else that's of import in a criminal defense lawyer's life. I know you've asked questions about what does it mean in respect to family. I think that my relationship with my family is of a type all its own. Irene and I have been married going on 56 years. And I think we love each other more today than we did yesterday, which is more, and so forth, and so forth, and so forth. We're kids when it comes to our relationships together. 5 remarkable people as our children. I miss very much time that I did not spend with them and with Irene. But we are composed of so many different things. And what I am today, for better or for worse, is in large measure attributable to my life as a criminal defense lawyer. There have been experiences with NACDL, there have been experiences in the courtroom that have gone far to molding me. We were talking to somebody, I think it was last week, and we were talking about having the strength. Yes, it was at the, we had attended a memorial service last weekend for a relation by marriage. And we were talking about facing up to the problems of age and deteriorating lifetime partners. And I said that I didn't believe the strength to deal with that sort of unwinding of our lives. And I also said that it would have been a very easy thing for me to say if I were a young man, late teens, early 20s. But over the years, times have changed. And being in the court, trying the cases, lends a tempering to the components that you are, to where you can become, in the street word, tough, where you can live with it, where you can challenge it, where you can fight it, and sometimes succeed. The NACDL stands for much of that. We went from the happy little club, which it was for many years, to what became some watershed times in the 70s. Charlie had mentioned the National College for Criminal Defense. The funding of the National College for Criminal Defense was basically LEAA monies, but with a commitment for, if my recollection serves me, something like $15,000 from the NACDL. And we jealously guarded our participation in the college. And there were some members of the board who did not want to assume the responsibility, were unwilling to join in something with which they were totally unfamiliar until, oh, I remember this one. I swiped something from Bates. They had the National College for District Attorneys at Bates. And we were being taken through Bates, and we came to a wall that was one of the steel bookcases, and they had all kinds of publications for the prosecutors on there. Well, there was a publication that had a kind of a circular for participating in the District Attorney's College and what it meant to the prosecutors, written by a very notorious prosecutor from New York, Maurice Najary. And you may have heard in this day that Rudy Giuliani was tough. Rudy was a pussycat compared to Maurice Najary. And there was this circular, and I picked it up and I saw it, and I couldn't believe what I was reading. It said, amongst other things, that the greatest experience that I have felt and that I continue to feel in my life, even greater than the sexual experience, is when a jury comes in and says, guilty on all counts. We got on the bus to leave Bates, and I stood in the front of the bus, and I read that with expression. And of course, with some, shall we say, allusions to what Maurice Najary was talking about when he was saying short of the sexual experience, and Gil, of course, had a few gruff remarks to make. And it was a unanimous decision from all of us on the bus that the National College would be formed right then and there, and the $15,000, as Charlie has indicated. Yeah, well, naturally, all of us have personal recollections. Participation of us as individuals is easier to recall than participation of others. So there's that problem in this kind of oral history. But I think that by the second year of the operation of that college, there was a watershed situation. And you know, there have always been differences as amongst those. Well, it started to become pronounced, differences as to viewpoints or what is important. And with the college, there started to be attendance by more, and I say it advisedly, of the younger lawyers. And the younger lawyers were more inclined to take less temperate stands. And the college got evaluations of those who were attending, those who were speaking, those who were presuming to teach. And the remarks, the evaluations by, in the second year, were that, oh, so-and-so, referring to an older lawyer, is not relevant to us, doesn't understand, or what's important to us is such and such. And I remember that I was trying a tax case in the Southern District of New York, and the prosecutor, who coincidentally, his name was Bush, I don't know if he was related or not, had served a subpoena upon me, seeking records that I had accumulated in what I believed was my file to help me in the defense of this particular case. And naturally, very easy, I was going to resist that subpoena to the very end because I felt it was important not to disclose why a particular piece of paper was in my file, because that would lead the prosecutor to what my thinking was in respect to the defense. I grabbed a lunch break and I spoke for about an hour in very vigorous tones about what some of those lawyers whom they found to be no longer relevant had meant to me and had put into me the resolve to look the United States government in the eye and say, you can take me, but you won't get those papers. It changed much of the attitude of those who were there. Mel Lewis, who was then assistant dean, Tony Freelo, past president, the one who gave us the term Liberty's Last Champion. Mel Lewis came over at the end and hugged me, crying. He said, you gave us a college. I say it, frankly admit, tears come to my eyes. Because if I did do that, and this gets around to answering something that you said a bit ago, then I have fulfilled something which could be interpreted as a goal. That if I did do that, then the odds are that there are other lawyers who heard of the experience who will find the same strength to deal with the government on behalf of their clients and on behalf of what it means to be a criminal defense lawyer. And that is where the NACDL has shown. Charlie, in his interview, mentioned Wounded Knee. Oh my God, what an experience. And let me tell you how far we've come. The Wounded Knee situation came to the NACDL while we were at our annual meeting in Dallas. Charlie was president, so naturally the annual meeting was in Dallas. And it was attended by a huge throng of lawyers. There were about 30 of us there. And probably the only dues-paying members in the NACDL. And while we were there, we received a telegram from Joseph Beeler, who was a director for a period of time, advising us that there were no lawyers, underscore the word no lawyers in South Dakota who would undertake the representation of close to 150 Native Americans charged with various violations of the Assimilated Crimes Act and who were awaiting trial in the United States District Court, District of South Dakota. The telegram was requesting help. I think Bob Heaney was due to be the next president. So everybody figured we're going to stick somebody with a dirty deal, may as well stick Bob. You know? So he was probably unanimously selected to go, we didn't have any money, to go on his own dollar to South Dakota and report to us in the fall meeting as to, hey, what's going on? Bob, to his everlasting credit, went out to South Dakota. And I don't remember where we met in the fall, but we met in the fall, and Bob reported to us that what Joe Bieler had said was the truth, that there were this large number of pending indictments, and that no lawyer in South Dakota would undertake the representation primarily because it broke their rice bowl. Their clients were the farmers who were living in dread that the Native Americans might reclaim some of the land, or there was one conflict, another conflict, the third conflict. So there were no lawyers. Approximately 25 of us by the end of the year had volunteered to represent the Indians, Sioux. And
Was this done through NACDL?
NACDL, this is NACDL. What we had decided at that fall meeting was that, hey, we're a bunch of guys, just get together, we have our fun, we enjoy each other's company. But then these other people in these other organizations are out in front on these various civil rights issues, and as far as we were concerned, they knew how to get themselves arrested, but they didn't know how to defend those who were charged with, in this instance, with serious crime, and that we should be out in front. So they said, hey, great idea. Little did I know that the one they intended to put out front it was myself. That very devious, like with Heaney and then this. You know, you're dealing with people. As I was saying, this group of lawyers was extremely deft. I won't go so far as to say that they were manipulative, but they could certainly handle a given situation. In any event, we went out to Rapid City. We had received a call that there was going to be a meeting of the Oglala Sioux and some related Native Americans in Rapid City, and that we should attend. I don't recall exactly how it came about, but I'm sure that Joe Bieler probably put together this particular meeting. Well, the 20 or so of us went out there, and we went to this hotel in Rapid City, and there was a meeting going on. And the meeting consisted in large measure of Russell Means and Mark Lane, each of whom had received and would receive considerable publicity in the ongoing Wounded Knee situation. Mark Lane and Russell Means were holding forth loud and long about the Treaty of '68 and how they believed that the Sioux had certain rights under the Treaty of '68 and that there was only one defense to interpose, and that was their political defense. And the treaty had to be litigated and nothing else. Well, you can't tell 20 trial lawyers that they are to follow orders. They just reflexively will reject that kind of command. I would guess that probably half left that evening. Abandoned representation would have nothing whatsoever to do with something which was not of their own making or design. Say 10 of us remained. And I know that one of the reasons why I remained was a deep and abiding curiosity as to what this all was all about. And being half a history buff, particularly of American history and the opening of the West, I had an abiding intellectual interest in it. And the next day, we got into a couple of cars and went out to the reservation. Went out to Pine Ridge Reservation and visited Wounded Knee. It was just a soul-searing shock to me to see the conditions under which these people were living when they were allegedly under the care and maintenance of the United States government. I never conceived of American citizens, particularly Native Americans, living on dirt floors in a one-room shack. South Dakota, with the winter that they have to experience in a place without central heating, they had some electricity, some running water, but that was it. I'd gone into the supermarket and I was on a cottage cheese kick at the time. Went into the supermarket at Wounded Knee, and I recall a small container of cottage cheese was about 4 times what it would cost at our supermarket back home. The people were being looted of whatever they had or could have by Indian traders and by thieving people of their own tribe, all maintained by the Bureau of Indian Affairs. We went into a meeting hall out there and were introduced to a number of the defendants. The first name on the first indictment, which was scheduled to be tried, was Francis Killer, K-I-L-L-E-R. And, well, you know, I don't know what you think of, what you associate with the word killer, but I did not expect to see a woman about 4'11", looking to be about 80 years old, hobbling, as being Francis Killer. And then I learned she was in her 40s and was just stunned by the ravages of poor diet, though under federal care. We then went out to the trading post and the church. And went out to the trading post, and I don't know whether you've ever had the experience, that I guess could best compare to what was filmed in what I think one of the great movies, 12 O'Clock High, where the actor Dean Jagger, long after World War II has ended, goes out to the base at which he was an officer during World War II. And he goes to, well, what is obviously a runway that is now marked with patches of grass, broken concrete, and he flashes back to what it was. And that's the movie. I stood on that hill and I saw the massacre of Bigfoot and his small tribe, the band that was following him. And that wasn't, in my lifetime, all that long ago. I was born in 1923. It was only between 25 and 30 years before that slaughter took place in our United States of persons in rags, if anything, looking to get warm, snow on the ground, temperatures, those who know South Dakota, below zero, wind chills way below zero. And we killed each and every one of them. And I said, I'm here for the long pull. We went to trial shortly thereafter. And that first case had 4 defendants. Francis Killer, 3 others whose names I don't remember, although man kills underwater sticks in my memory, and I don't know who got stuck with him. But the lawyers who were representing the first 4 defendants, I represented Francis Killer. Jim Shello represented somebody else. Doug Thompson from St. Paul represented a 3rd, and Tony Freelo from Houston represented a 4th. Day or 2 before we were supposed to start, we were advised by the court that the government had chosen to dismiss that indictment. And I had the stupidity of remarking that, well, I had already made arrangements to come out to Sioux Falls, so before I knew it, I was shanghaied out to Sioux Falls handling the second case. Well, I didn't realize at the time that that was going to mean 6 months in Sioux Falls, South Dakota. The 6 months I didn't suffer through totally alone by any stretch, because there were some other lawyers there who were associated with what was called the Wounded Knee Legal Offense Defense Committee, which I thought was one of the great names of all time. This is one of the few times I've been able to pronounce it without stumbling. But I think I must have been in trial about a month when I dragged Jim Shello out there. And he spent the remaining months out there as well. The trial judge was Judge Erbaum, whom I worship to this day, and he acquitted the defendants and then saw to it, without going into the long Wounded Knee story, which I know you've heard. He took care of the pending indictments very nicely. But to show you how it all comes about and how important it is within the history of the National Association of Criminal Defense Lawyers, is that Judge Erbaum was a young federal judge at the time he undertook that case. He's from Nebraska. Nobody in South Dakota could sit on the cases. So he took senior status a couple of years ago and has now basically retired from the bench. The Inns of Court, as well as the local bar association in Nebraska, is giving a surprise testimonial dinner to him. And they contacted me and offered me every inducement and blandishment imaginable to come out and tell of Wounded Knee and Judge Erbaum. They say that he has always spoken of what the, uses very flattering terms, of what the representation of those of us from the NACDL meant to him in teaching him what was basically, in his opinion, our justice system's shining hour. That it influenced his judging for, well, it's close to 30 years now. And that he treasured each moment. Learned from the lawyers, learned how much we contribute to our national history by being lawyers doing what we considered was our routine job. I will go out there at the end of April and I will tell the Wounded Knee story. I had been out in Nebraska. I was invited by the Nebraska Bar to participate in a program. Well, let me tell you just how it all came about. My secretary, who knew what my relationship was as I felt it to Judge Erbaum, comes running into my office one day and says, Judge Erbaum's on the phone. I pick up the phone, Judge Erbaum, Judge Erbaum. I'm really so excited to hear from him. And he asked me if I would do him a favor. I said I'd walk across a tundra on bare feet for you. He says, no, 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 no. I just would like you to come out and participate in a seminar. I said, fine, what is it? I don't care. I'll be there. I'll be there. Well, what he wanted to do was try a case in the morning with Bob Fisk, who was special prosecutor, had been United States Attorney in the Southern District of New York. As the prosecutor, myself as the criminal defense lawyer, he would sit as the judge. That would be the morning's activities. Afternoon activity would be the same case tried in front of an English judge by barristers. The contrast, it's wonderful. Yeah. It's a marvelous idea. And he wanted to make sure there was enough time to do it. So we were supposed to meet. Well, I hadn't seen him in, what, 20 some odd years. Irene and I finally get to the hotel, and I'm checking in, and something attracts my attention. I look over my left shoulder, and coming down the stairs are two couples in dinner wear, and I look and my mouth drops open. One of them is Judge Erbaum, who sees me at precisely that moment, and he reacted the same way. He ran down the steps, maybe I mounted a step or two, and we embraced each other and cried. It was just overwhelming emotionally for the both of us. Well, the next morning, we were due to start at about 7:30. We go down there, everybody's given assignments, so to speak. And, okay, let's start. And I said, I'm not going on. I'm not participating. Well, you got 200 and some odd people sitting out there, half the working bar of Nebraska, and they have somebody pulling a temper tantrum, or its equivalent. You know, what are they going to do? So they said, "What is it, Albert? What is it?" I said, "I want to make my speech about Judge Erbaum." So, you know, it's fine, whatever you want, let's get on with the program. So as soon as we finished in the morning, I told the Wounded Knee story, with Judge Erbaum sitting just to my right. His wife was directly in front of me, seated alongside of Irene. And as you know, I've told that story hundreds of times, probably. I think that particular version or rendition of it was the best. He was, what can I say? It doesn't do it justice to attempt to describe his emotional reaction to those days. Oh, we spent the rest of the day together. We spent the evening, and maybe the next day, I'm not sure. And he was detailing to me how much he had changed as a person being a judge, the powers that Jerry Cogan was talking about yesterday, as a result of that single experience, and of having before him handling an enormously politically charged case, lawyers, as he termed it, of unique and awesome ability. Well, those are very nice words for any practitioner to hear. And like with a lot of other things, if you happen to be the subject of some flattering remarks, you hope deep in your heart that they are true. But I know that by the end of the Wounded Knee experience, I was not only a different lawyer, I was a different person from the one who started. So I can join with Judge Erbaum in talking about how different the experience was. Well, the NACDL handled, in total, about 140 cases. Some of them required very little effort because Judge Erbaum dismissed them kind of out of hand. But it was the first of a mass participation by the membership in something of public interest. And it kind of was the forerunner to what was going to take place within a year or two thereafter, if I have my chronology correct. Jim Shello became president. We had a meeting out at Lake Geneva. The annual meeting was out at Lake Geneva. And the Board of Directors meeting was out there as well. And I think because of the Wounded Knee situation, there were a number of people who were new membership. There was interest in the association other than that to which Charlie and I and Jim were accustomed. So these new members were there, and I don't recall the exact genesis of the idea, but I do recall, because I wound up being the point person on it, moving the enlargement of the Board of Directors to include some of the, quote, young lawyers. Okay? Gil Rosenthal, who I revere, was very much opposed to it. He wanted the association to remain what it had been, and that was this intimate group of persons, in truth, of some of extraordinary ability, but truly, in many, many respects, the cream of the trial bar. And he wanted it to stay that way. He felt that the collegiality which flowed from this small group would be diluted by bringing in many more people, and also people who had not, let's say, passed the same tests as the older ones had. And I wound up confronting this dear and treasured person. And we had a bit of a disagreement, a bit of an argument. And what happened is when it finally came to a vote, the board of directors was opened up. And that's how come on the board of directors you got people such as David Russell, and I remember Dominic Gentile. What's his name? Bruce Lyons?
One way.
Yeah, Bruce Lyons. I don't think Jeff came on that year. I think he came on a little later.
Thank you, Irene.
But he came on, but there was room then, and an open-handed policy of admission of the younger lawyers. So the association, as a result of the Wounded Knee experience, took a very dramatic change. Jerry Lefcourt was talking about being recognized as a result of his experiences during the civil rights days. Those who knew about Wounded Knee gave me a similar type of accord, you know, very flattering, but a tribute to probably what was a result of the collegiality of the old organization. The association started to grow a bit, and the next major situation was either 79 or 80, when I was president, and very early in my term, I decided that this is ridiculous. There's no way in which I can have my office handle whatever has to be handled by the association. The secretaries had enough to do, and I had enough to do. And to depend upon the president to handle the bookkeeping, to handle the correspondence, to handle the finances, etc., is preposterous. We need an executive director. Well, the midwinter meeting was, oh, we picked good places, was Minneapolis. Or maybe it was the spring meeting, but it was a meeting in Minneapolis. And at that time, there were still people active in the association, such as Paul Smith and Maury Walsh and Gill. And I really don't recall some of those who were at that meeting. Were you at that meeting? And I proposed the executive director. Well, you would think that just throwing a basket full of cobras on the table, the reaction from some of the older ones was bordering on violence, to the extent that Paul Smith, with whom I had a very warm relationship, said, "I'm destroying the association, and that the death of the NACDL will be on my head," because I wanted an executive director. Felt it. We should have an executive director. Well, as time has gone by, Paul's doomsaying was really inappropriate, and I'm delighted that my predictions as to where the association could go did come true. We've gone through a number of executive directors, some of whom I would be hard-pressed, at least one in particular, I'd be hard-pressed to give a sip of water if he were under a sand dune in the Sahara. But others just did the best that anyone could think of. Oh, some, we have a current executive director who seems to be probably the best that we ever have seen or ever could imagine having. But a number of the others did their best within their capacities, and that's all any one of us could do. The one whom I don't care whether he's thirsty or not put himself above the association. And I think at one point created a circumstance because of his mistreatment of a president to come. Put the association close to splitting it asunder. Another time the association nearly fell apart was at the end of my term. Maybe you would think that my term as president brought the association repeatedly to where to where it would end, but I didn't intend that. We were going to have our annual meeting in New Orleans, where we had a director who was probably, there were two directors, two participants in the association who were really not trial lawyers, but we loved them. One was Jerry Schreiber from New Orleans, and the other was Sam Barney? What? No. Sid Barney from Virginia. Whatever, someplace with a Virginia in the name. And Jerry Schreiber had really put his whole reputation on the line for the annual meeting in New Orleans. And by this time, things had changed markedly from that '73 occasion when we were in Dallas in Charlie's tenure to where we were to what we were anticipating at the end of my term. So New Orleans sounded like a great spot. He had made all kinds of arrangements. Well, along came ERA. And Louisiana was a state that did not seem to favor that amendment. So, wow, we were off to the races, and the association was threatened by those who felt that the end of the world would come about if we met in Louisiana because of the continued restrictions on women's rights. So, regardless of poor Jerry Schreiber, we moved the meeting to the Coronado in San Diego. What we took with us was the fight. So at that meeting, all hell broke loose for some reason. I don't recall. I don't recall which. But we were able to get past that. And for the association to start to go up on almost, well, really, it was a vertical. We went up like an elevator. I would guess that we had 700, 600 real members at the time of the San Diego meeting, and by 1990, say 10 years later, we must have had over 5,000. And then, as Jerry said, by 97, he was riding the crest of the wave, and there were thousands more. Times were different, outlooks were different, membership was different, membership is different. And I am amongst the first to admit that the ways in which Charlie, Jim, myself thought we were serving the bar might not do it today. That the demands of the bar are different today. That unhappily and unfortunately, the struggles in which we engaged for our recognition also brought with it our requirement for integrity, civility, and dignity. No one of us were ready to throw bombs into the courthouse. We would throw verbal bombs. I don't think that anyone could point to a case, a situation that one of us tried where we took a step back. But I think it would also be difficult for anyone to point to a case that we tried where we did not have the respect of the court and in truly antagonistic situations earn the respect of the court. That we walked into court and they knew who was coming in. Maybe we didn't realize it as such. We didn't walk in as braggarts and looking to make our marks with some kind of braggadocio. We came in as lawyers, proud to be lawyers, and wanting the world to know that we were lawyers. And I got to go to the thing. It's almost 2 o'clock.
May I ask just this quick question?
Nope.
Thank you. Albert, you seem to be on a mission to talk to young lawyers. During times when you and Irene can be on cruises, relaxing at home, fishing, doing whatever you wish, you and Irene are on airplanes crisscrossing the country, speaking to one group of criminal defense lawyers after another.
True.
You're involved in the ABA. What drives you to do that and why?
Because I believe in our system of justice. And I believe that we achieve our system of justice only if the defense lawyer is skilled, is honorable, and stands as a hallmark for that which is good and honorable. And the only way that that can be accomplished, except through pain and needless ill experiences, is by we older lawyers sharing with the younger lawyers what life really is in the courtroom. I went to a law school which now is rated an equivalent of Harvard or Yale. It wasn't that highly rated then, but was a top-flight law school. And we had nothing vaguely resembling instruction in respect to trials or trial law. Nothing. If Gil Rosenthal didn't take me by the hand, I would still not know where the courthouse is. So maybe I feel, and I've said this, Jeff, maybe I feel that I'm paying my debt to Gil by doing it, but that's too simplistic. I truly feel that my experiences, not only as a lawyer, but with the association, meeting some of the lawyers, getting to know some of the lawyers, seeing what the lawyers have done, what they've experienced, what they've lived through, seeing and understanding, because I lived through it, in truth, the courage it takes sometimes to be a criminal defense lawyer. I want to share that. I want my dreams of individual rights and freedom to be real for my grandchildren and perhaps my great-grandchildren. As you know, I have a daughter who sits as a judge today. Shortly before she graduated from college, I was interviewed by the ABA Journal concerning then emerging problems with lawyers. And I remarked that I was glad that my daughter, who would be graduating shortly, had not chosen to go into law. And that if she had chosen to go into law, I would certainly be suggesting to her not to go into the criminal field because it was too dangerous. That the real risks of running into a vengeful government, be it state or federal, were almost overwhelming, and I, as a father, did not want to have those worries, those cares, those concerns. Well, daughters being daughters, she promptly went to law school and did her 14, 15 years as a public defender and became a judge. And I can't tell you the pride that I feel when lawyers come over to me, and some of them are here at this meeting, come over to me and say, I was in front of your daughter the other day or last week or last month. She is great. When the Dade County Bar gives her a rating that is the highest of the new judges. You watch her a little bit, and it's because she was a trial lawyer who never forgot what it is to be a trial lawyer and what her obligation is, not only to the bench, but to those to whom the bench belongs. That is, the people who appear before her.
Albert, we're picking up young new members all the time, and I know you have to go to this lecture, but briefly, I want you to speak to them and tell, what do you want to tell a new member, a young man, woman, just becoming a criminal lawyer, joining NACDL?
That you will have guidance, you will have support, you will have teaching, and you will be able to fulfill the oath you take when you're admitted to the bar fully and completely because of your affiliation with the NACDL.
Albert, thank you.
Albert.
The same way Gil was to you, you have been to me and to many others, so it's an honor and a treat, and we salute you. Thank you very much.
God bless you.
Albert.